State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney appearing for the state. Mr. Robinson, are you here?
I am here.
Welcome to Kansas, where one man's creative interpretation of the law collides head-on with a judge who's heard every trick in the book. Today's case isn't just about a speeding ticket, it's a masterclass in how not to represent yourself. The defendant, Tremaine Robinson, strides into court armed with sovereign citizen rhetoric, challenging the very foundation of U.S. jurisdiction. But across from him sit two forces of reality, a calm, razor-sharp Judge Webster and a prosecutor who's methodical enough to dismantle every pseudo-legal claim in record time. Expect tension, laughter, and a bit of second-hand embarrassment as internet law theories meet real-world accountability. Stick around, because this hearing unravels fast, and by the end, you'll understand exactly why courtroom decorum and actual legal training still matter. Let's step into Judge Webster's.
Is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge.
Where it gets interesting. Robinson invokes special appearance, a legitimate legal concept when used correctly. The catch? Only a licensed attorney can file or argue it properly. By trying to reserve his rights and challenge jurisdiction, he's parroting language lifted straight from internet message boards. The problem, courts operate on precedent, not copy-pasted buzzwords. Judges instantly recognize this pattern, and instead of gaining leverage, defendants just lose credibility. Think of it like bringing a YouTube comments section to a chess match. You might sound confident, but you're not actually playing the game.
Not given a copy of the ticket issued by Trooper Collins.
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a
victimless crime argument is a classic sovereign citizen talking point. The flaw? Law doesn't only protect people after harm, it prevents harm before it happens. Speed limits exist precisely to stop victims from being created. In courtroom logic, the victim is the state of Kansas itself, representing the public safety interest. When Robinson demands a person he hurt, he's missing that driving 92 in a 75 zone already violates public safety law. It's the same as saying, no one's hurt yet, so rules don't apply. Try that with a loaded firearm in public and see how fast that reasoning falls.
Enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So, your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appear to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office.
This is where procedural precision matters. The prosecutor calmly explains that Robinson's discovery motion lacked a certificate of service, a small detail that carries massive consequences. Without proof he served the other side, his motion is legally invisible. It's like sending a letter and forgetting the stamp, then wondering why no one responded. This moment highlights a truth many self-represented defendants learn too late. Courtroom procedure isn't bureaucratic fluff, it's the engine that makes justice run smoothly. Miss a step, and your entire argument.
On July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph, ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear. Talking again about an administrative agency and tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. Court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, comma.
The judge has seen the telltale signs: odd punctuation, beneficiary titles, and signatures with hyphens and colons. These are all hallmarks of sovereign citizen documents meant to confuse the system with wordplay. But judges don't play that game anymore. They read these as red flags for nonsensical filings that delay proceedings and waste resources. Judge Webster doesn't need to get angry because she's already won this battle 100 times before. Her calm, measured demeanor isn't apathetic, it's authority under control.
Are inherited in the people, Legislative Assembly. Officer Collins K. issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed, end quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records. He says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days, or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves.
Robinson admits he served his discovery motion yesterday. That's the moment everyone watching knows this is going off the rails. Expecting the court to produce records overnight isn't ambitious, it's delusional. Courts run on deadlines and notice, not wishful thinking. The judge gives him every benefit of the doubt and still finds his filing untimely. That's the difference between perceived rights and practiced law. One sounds good on paper, the other wins.
On this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road of the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se, and that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se, so Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Judge denies his motion and orders trial to proceed. You can feel the air tighten. Robinson claims he's not available, which in court language translates to "I'm not prepared." Meanwhile, the prosecutor is laser-focused, ready to back up every point with precedent. It's like watching an amateur boxer step into the ring with a seasoned champion who knows exactly where to hit. And as the state begins reading binding case law to counter the sovereign claims, Robinson can only object on hearsay, proving he's still fighting the wrong battle in the wrong arena.
Filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable, and I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No,
What are you doing there with your computer?
right now I was looking for a doc.
That's where we'll leave today's courtroom standoff. In the end, the law didn't bend, the judge didn't flinch, and the defendant's paper fortress collapsed under the weight of real legal precedent. Cases like this remind us that while the internet might promise shortcuts to freedom from jurisdiction, the only real path through the justice system is knowledge, preparation, and respect for due process. Judge Webster handled the chaos with patience and precision, proof that calm authority always wins over performative defiance. If you found this case as shocking and
Be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive opening statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case involved a sovereign citizen where the court noted in the memorandum opinion.
Objection here.